morning, and can I just introduce to you our chairman this morning is David Levin, one of the commercial silks on our list, who particularly works in the construction area and has, I hope, some knowledge of proportionate liability himself, or apportionment of liability. So our chairman, David Levin.
This morning we have a presentation to try and assist everyone in their understanding of the Part 4AA provisions of the Wrongs Act, dealing with proportionate liability. In general terms, as you probably know, the court in a proceeding to which the section applies must give against each defendant who's found to be jointly or severally liable to a plaintiff for damages judgment only for such proportion of the total amount of the judgment as the court thinks just and equitable, having regard to the extent of that defendant's responsibility for the loss and damage of the plaintiff. That's a nutshell of the provisions, and it really is a pretty awful set of legislative requirements. It's like a series of hoops. Proportionate liability is the dream child of insurers. They lobbied for its enactment, and basically, it seems to me, they're the ones who benefit. The losers are the plaintiffs, plaintiffs who probably only have one time in their whole lives in court, whereas the insurers are there every other day. And they used in the past only to have to sheet home their claim against one party who was to some extent responsible and hopefully had deep pockets, and then leave that defendant to try to offset its liability against any other parties that it could find responsible. Now the plaintiff has to find the parties responsible, and it's the plaintiff who suffers the loss if one or more of the responsible parties is without funds, insolvent, without insurance and so forth, or just missing in action. As counsel in the Aquatech case that ran before David Byrne some years ago, which wasn't at a time when the Wrongs Act provisions were in force, but when the Building Act provisions were in force, I had personal experience of trying to navigate through the proportionate liability provisions, which are very similar. And in that case, David Byrne said the procedural complexity attending the proceeding, and I suspect a cause for great difficulty in achieving a commercial settlement of these disputes, has been to a very large extent the consequence of the suggested operation of the apportionment of liability provisions. Now, nothing has been made any simpler by the current provisions, and certainly in running actions I've found it extremely difficult to understand exactly what you have to do, and if you're trying to settle cases, it is very hard if you are either the plaintiff or one of the responsible or possibly responsible defendants to work out how you can possibly frame an offer of compromise that will be effective and will protect you or your client for any of the eventualities which might occur. Now, this morning we've got the benefit of two people who really ought to know their stuff. I'll firstly introduce Kyle Naish. Kyle was in a former life a solicitor with Deakins, and I think before that with Minter Ellison. His principal experience is in commercial infrastructure litigation in the superior courts and in arbitrations. He holds a dual degree in economics, commerce and law, and is currently lecturing in corporations law in the LLB course at Melbourne. So without further ado, Kyle Naish.
Thank you for the kind words, David, and the excellent introduction to what is a rather complex and difficult legislation which we're considering today. Just in brief compass as to the structure in which the two talks that we'll be giving today, I'll be giving a brief introduction as to the general principles of the Act, the Wrongs Act Part 4AA and how it applies, and I'll speak in general about the breadth of the Act and its scope and application, and specifically how to determine who is a concurrent wrongdoer and what the parties' considerations might be as either plaintiff or defendant in terms of whether or not they join a party as a concurrent wrongdoer or whether indeed they oppose the joinder of the same. Michael will speak about the more curly issues of settlement in the case of a claim where the apportionment legislation is invoked, the question of pleadings and how one draws pleadings in that sort of instance, and also, time permitting, speaking about cost issues and possibly contributory negligence. Now, I hope you've all received your show bag this morning, which contains a copy of the paper to which we're speaking today, and also a copy of the proportionate legislation itself, because some of what I'm saying will require you to actually have a look at the nitty-gritty and have a look at the legislation. Part 4AA claims were first introduced by the amendments to the Act in 2003, and it took some time for litigation concerning these provisions to actually come before the courts. And so, for a significant period of time, parties weren't actually aware of what the legislation may have meant, and there was a fair bit of speculation about that. From experience, even though the changes occurred in 2003 and came into force in, I think, 2004, there are still a significant proportion of the practicing community who are perhaps a little unsure as to when the Act applies and how it should be applied. Now, I've referred in the paper, we've referred in the paper there to Justice Palmer's his explanation of the purpose of Part 4AA, and he puts a slightly different and probably slightly less accurate tinge on it than David did just before, when he speaks about the perceived injustice of the fact that a plaintiff can sue a deep pocket party under the common law if they're joint and severally liable, and seek the entirety, compensation for the entirety of the loss and damage they've suffered as against that party. And true it is that the changes to the legislation which we're considering in Part 4AA of the Wrongs Act, and I might add the comparative provisions of other state legislation and the Trade Practices Act, arise from pressures put on the legislators by insurance companies. And they do operate to the detriment of plaintiffs. However, the reason for it is that there was a perceived injustice, in particular to insurance companies, that they were essentially paying more than on behalf of their parties and their clients than they should have, given the comparative responsibility of those parties in the entire claim which was before the court. So the function of the Act is to prevent the hunt for deep pockets. And by apportioning liability for relative blame, then a party's liability and their culpability can be more closely aligned. That's the purpose of the Act. So how does it do that? Well, the main provisions which you need to look at to understand the operation of the Act are sections 24AF, sections 24AH and 24AI. And we'll start with section 24AF. And what that does is identify the type of claims which fall into the category of an apportionable claim. And the provision I'd like you to look at briefly is section 24AF subsection 1. And that states that the part applies to a claim for economic loss or damage to property in an action for damages, whether in court, contract, statute or otherwise. So it's a very broad scope under which this part applies. However, the kicker is that it must arise from a failure to take reasonable care. Now, I'll go into that in more detail later, but I'd like you to consider both the breadth that the provision starts off saying that it applies, and then the condition which is then ascribed to the end of that, from a failure to take reasonable care. Subsection 2 says it requires 2 or more apportionable claims. If 2 or more apportionable claims arise out of different causes of action, then liability for the apportionable claims is to be determined in accordance with the part as if it were a single claim. Section 24AH goes on and says, well, okay, who is a concurrent wrongdoer? And 24H defines a concurrent wrongdoer in relation to a claim as a party who is one of 2 or more persons whose acts or omissions independently of each other or jointly cause the loss or damage that's the subject of the claim. Now note the language that's used in that is different to the language that's used in section 23B, which is the general contribution legislation which is contained in the Wrongs Act, the other portion of the Wrongs Act. For a long period of time, people were of the view that the loss or damage that was being considered by this legislation was different to that which was held to be considered by the contribution provisions of the Wrongs Act in section 23B. But late last year there's been some considered Court of Appeal authority which essentially says no, they're the same thing. And there are some implications of that we'll get into shortly. I'd also draw your attention to section 24AK of the Act. And what section 24AK of the Act says is that where someone's previously recovered judgment against a concurrent wrongdoer for an apportionable part of the claim, then essentially they can still be brought back into the proceedings, but there can't be any, or their responsibility can still be considered as part of the proceedings, but there can't be any further recovery as against them. So assume for a moment that the plaintiff sues a particular defendant in respect of loss or damage that it has suffered from. There is judgment against it, it recovers that judgment, but it then determines that in actual fact that there are other parties who are responsible for the loss or damage so suffered. Or that, for example, perhaps it can't recover all of the loss and damage that it's entitled to as against that defendant because that defendant's become insolvent in the interim. Well, if it then decides that it wants to sue 2 or more other people, then those other prospective defendants can, in essence, join the third party, subject to section 24AI, and essentially say, well, look at the blame of that other party. You have to consider that in determining how much we're responsible for the outstanding loss that the plaintiff hasn't recovered. And the law says, while that other party can't be held to pay more than they've already paid, the court still has to say, well, when determining how much the other defendants have to pay, the court will take into account their comparative responsibility. Section 24AI, to which I've just referred, says that in apportioning responsibility between the defendants, the court mustn't have regard to the comparative responsibility of any party who is not a party to the proceeding. And the importance of this provision is that it, in essence, encourages defendants to join parties to a proceeding. Because if they're not joined, then the court won't take any notice of their comparative responsibility. The result of that is that proceedings are complicated by the operation of this Act, because there is a legislative inertia, in a sense, to join further parties to a proceeding. A defendant will be more likely than not to want to join other prospective defendants to the proceeding, because if they do so, then their comparative responsibility may be reduced. So it's in the interest of a defendant to join other parties in. And if that then be the case, the entire proceedings are further complicated. And that leads to some of the complications to which Michael will be referring to in respect of settlement, pleadings, costs and other matters. So I'll talk for a moment about the breadth of the part. The language of the provision states that it applies where there's a failure to take reasonable care. And there's a misconception in some portions of the legal community that essentially is shorthand for negligence. But it's clear from the language used on the face of the Act that there is a broader scope to negligence. There's merely a failure to take reasonable care. So if one is the subject of a claim, whether it be in breach of contract or for misleading and deceptive conduct pursuant to the Fair Trading Act, it's not necessarily the case that that claim is not an apportionable claim. Sorry. Yeah. And in contract in particular, contracts for services or production of goods, products liability, is one area in which a failure to take reasonable care, notwithstanding the fact that there's a concurrent contractual duty, that is one of the, in recent case law, has held to be one of the applications of this Act in a very big way. Now, it should be clear on the face of the legislation that would be the case, but there has been a misconception from the beginnings of the operation of this Act right up until the current day. We still find practitioners who believe that because a claim isn't pleaded in negligence, that the Wrongs Act section Part 4AA does not apply. But it can apply and it does apply. And we've referred in the paper there to Justice Middleton's judgment in Dartburg and Wealthcare Financial Planning, and that decision is one of the most influential decisions about the operation of Part 4AA. So if you're at all interested in this area of law, I recommend that you read that case. And what his honour there says is that there's no requirement that there be a breach of duty of care for the apportionment legislation to operate. Instead, it must merely arise from or arise out of a failure to take reasonable care. And one of the things his honour says is it doesn't even necessarily need to be clear, based on the pleadings that are before the court, that there is a failure to take reasonable care. It might be that at the conclusion of all of the evidence and at the conclusion of the trial that it's clear that there's a failure to take reasonable care. And if that be the case, then assuming that the parties have properly invoked the apportionment legislation, then it will apply. Now, Part 4AA claims, therefore, can have a very broad operation, and they can sneak up on you because they're not necessarily stated in the pleadings that you're facing. And I'll give a few examples of where this legislation may apply. If we have an example of, say, there's a bank valuation, where a bank enters into an agreement with a valuer to value certain property so that they can determine whether or not they're going to provide a loan to a prospective lender. That's an example where there's a contract for services which exists, but if the valuer fails to perform their services with due care and skill, then they're failing to take a reasonable care. And notwithstanding the fact that the breach is one of a breach of contract and may be pleaded as such without pleading that there is a negligence on the part of the valuer to perform their duties, the Act will still apply, because the act which is being complained of, the cause of the loss and damage, arises out of a failure to take reasonable care. Another example would be, say there's a clothing manufacturing subcontractor whose job it is to dye certain products in a certain colour. Their services arise and their duty arises out of a contractual relationship between that subcontractor and the clothing manufacturer, who has, for example, who is responsible for creating the garment itself. Now, if that subcontractor dyes the clothing in the wrong colour, which means that that material is useless to the contractor, then if that subcontractor has, for example, entered into a supply contract with another person for the dye, which they use to dye the clothes, then it may be that they can draw that third party in as an apportionable claim. Notwithstanding the fact that all of the relationships which exist are contractual ones, and notwithstanding the fact that there's no contractual relationship between the person who provided the dye and the clothing manufacturer at the end of the line. There's a temptation among practitioners to try to, when faced with a defence, so when practitioners are acting for a plaintiff and they're faced with a defence which pleads Part 4AA, to attempt to stymie the operation of the Act by pointing to the pleadings which they're faced with. And Michael will go into this in more detail, but I'll just refer to the statement of Justice Pagani, which is quoted at paragraph 13 of the paper. And what Justice Pagani essentially says is that it's the task of the court to have a look at the general scope of what's happening here and the broad interpretation of the condition of the apportionment provisions and how it applies, and that task ought not to be frustrated by arid disputes about pleadings. Essentially what he's saying is the court is getting a little bit tired of practitioners who, when faced with an apportionate legislation provision claim, attempt to put a spanner in the works and say, well, look, you haven't ticked all the boxes. And, you know, here is an obligation which arises in tort only and tort hasn't been pleaded. Justice Pagani is saying, no, hang on a minute here. If we've got the relevant circumstances which may give rise to a failure to take reasonable care, then notwithstanding the fact that it may not be pleaded in specificity, then yes, the legislation may apply, yes, a party can rely upon it, and it's up to them to prove that matter at trial. The next question I'd like you to consider is, whose loss and damage are we talking about here? And if we move back to section 24AF, it says a claim for economic loss or damage to property in an action for damages, whether in tort, contract or otherwise. But whose damage? The damage that must be considered is the damage to the plaintiff. And so when considering who a concurrent wrongdoer might be, who does this Act apply to? The wrongdoer must be doing wrong to the plaintiff. Often Part 4AA claims are pleaded in the same way as third-party actions. I'll give it for an example, a building dispute. People, if there's a homeowner who contracts with a building contractor to build a home, that building contractor subcontracts out the brickwork to another party. Often there's an attempt to invoke the legislation by pleading the duty of care as between the builder and the subcontractor who the builder's trying to join. That approach would be a mistake. The duty of care which must be pleaded or must be alleged is that as between the subcontractor and the building owner. And the loss and damage to which that subcontractor must be responsible must be the plaintiff's loss and damage, not the builder's loss and damage for being sued by the owner. So the owner can't say, well, look, I'm being sued for this and you owe me a duty of care, therefore I'm going to bring you in, Mr. Subcontractor, under the apportionate legislation. Instead, you must be saying, if you're in the builder's shoes, Mr. Subcontractor or Mrs. Subcontractor, you owe the owner a duty of care and you're responsible for their loss as well as me if I am at all. So I'm going to bring you in under the legislation. And I hope that distinction is clear, because a lot of cases we see where there are attempts to prove the duty of care as between the co-defendants, when the important duty of care and the important loss and damage which must be considered is that as between the prospective co-defendants and the plaintiff themselves. the task that a court is setting itself to determine is the causal potency of each concurrent wrongdoer as between those wrongdoers and the plaintiff. And that it's the job that the court is then set with is determining how it is it can split the proportion of the loss and damage applicable by each defendant to the plaintiff. And so if you think about it in terms of saying, well, which one of the defendants is more to blame for the plaintiff's loss, then when you're drawing pleadings, you'll perhaps do so in an accurate fashion, because it's towards the plaintiff that you should be looking. Who's responsible for their loss? So how does this operate in practice? Well, Section 24AI will essentially force defendants certainly to consider joining concurrent wrongdoers as parties to the proceeding. But experience tells us that plaintiffs will do their very best to stymie that. They want to keep disputes simple. They want to chase someone who's got deep pockets, and there may be only one party with deep pockets. It's easier to settle with one party than it is with three. And so they may attempt to say, no, this claim is not apportionable. Whereas a defendant, on the other hand, will seek to say, well, it's not just me to blame, it's this person and this person and that person. Because if that blame can be proved, then that will reduce the amount that they may have to pay when judgment's finally given. So what we have are cascading joinder applications where each defendant who's joined to a proceeding may then look around and say, well, who else can I point the finger to? Once a party is joined, then the plaintiff is faced with a very difficult position. Consider yourself in the position of a plaintiff. You've decided to sue someone who's got deep pockets. All very well. That defendant then joins in a second defendant and says, well, it's not just me. But you don't yet have a cause of action as against that second defendant necessarily. If you don't have a cause of action, if you haven't pleaded a claim as against that second defendant, then you can't recover anything as against them. But it may be that you don't know what the circumstances are of the second defendant's liability towards you. In the case of the building contract to which I referred earlier, it may be that the homeowner has no clue as to what the bricklayer did. They don't know whether or not they were indeed the bricklayer. They may not have even met them. And so they may not actually understand the true liability of that proposed second defendant. And yet, if they don't make a claim as against that second defendant, then they've got no chance of recovering whatever proportion that second defendant may be liable. So they're in a difficult position. And to some degree, they're relying upon the first defendant's knowledge of the circumstances and the first defendant's understanding of just how much that party might be to blame. As a defendant, then, actually, I'll pause for there. So as a plaintiff, if you do decide to join that party, then you face a cost risk, possibly, because the second defendant, if you put forward a further claims against that second defendant on the off chance that they are indeed partially responsible, and they turn out not to be, it might be the case, and Mike will get into this in more detail, but it might be the case that you don't succeed, and therefore you've got a cost risk as against their involvement in the proceeding. So it's a difficult position that a plaintiff's in, because if they oppose the joinder application and say there's no arguable case as against the second defendant, they may be liable for the cost of the joinder application if they lose that. So either way, the plaintiff's in a difficult position. So in paragraph 22 of the paper, we say that where a defendant proposes to join a party for apportionate reasons, the plaintiff should give consideration to the cause of action being asserted and not merely roll over on the joinder application. And it's for part of that reason that plaintiffs often oppose joinder of parties, saying that the pleaded case is weak or untenable. And part of the reason that a plaintiff might wish to do that is so that they can, at the very least, if the application goes on, they can at the very least understand the basis for the jointer application being made. And then the plaintiff's in a better position to understand whether or not they should be making a further claim as against the second defendant. That's all I'd like to say. That's really setting the scene really for what Michael's about to say. Thanks for your time.